From O.J. Simpson to Amber Heard and Johnny Depp, the high-profile trial has become commonplace. But it's not just celebrities. On any given day, American court proceedings are raw material for countless news and entertainment programs. But cameras in the courtroom are not universal, and the legal system has had to wrangle with the rules and the impact of the visibility they bring. WATE 6 on your side legal analyst Greg Isaacs joins us to talk about this. It's good to see you.
Lori, it's good to be here.
Obviously, you're very familiar with cameras in the courtroom as an attorney and a legal analyst. So tell us about the decision-making process that goes into allowing that sort of media access.
Well, it's interesting. Rule 30 of the Supreme Court allows media in the courtroom in Tennessee. That happened in the early 90s, and I had the fortune or misfortune of trying the first case that was televised on Court TV, State versus Frazier. And it was interesting. This morning, Court TV is in town, and when I was at the courthouse, I saw the big SAT truck, how technology has changed. It used to be like a rock concert, and now it's just very unobtrusive, the cameras, the setup. But, you know, it's made things more accessible, and I think it's made the courtroom more accountable. And the judge has control, the presiding judge, and here's the factor he looks to in allowing cameras in the courtroom. One, does anybody object? Second, are there any safety concerns for a witness, party, or juror? Can you preserve the decorum and professionalism of the courtroom? And will it impact somebody having a fair and impartial trial?
We know the media side of things. We want to be there to let you all know what's going on. We're the eyes and ears of our viewers.
And Lori, it's interesting. People think that the media and attorneys are in lockstep and friends, but when it comes to cameras in the courtroom,
nope.
You're not my friend.
Yeah.
Because we don't want you there a lot of times. Yeah. And under Rule 30, it's very powerful. The media has a right to object if there's a limitation. Which you have done. You've got standing. There has to be an evidentiary hearing on, let's say, an issue of safety for a witness. Then there has to be a proof that it is a substantial risk, and then the court's got to do a written opinion and an order. So anytime you try to limit media coverage, a very high hurdle here in the state of Tennessee. Federal courts, unlike state courts, media coverage is prohibited. So when you see the Trump trials, that's why some are televised and some are not. Appellate courts, there's only two circuits, the 2nd and the 9th, that allow media coverage, only in civil cases. But, you know, cameras in the courtroom are a big part of what we do on a daily basis.
Yeah, all right. Greg, thank you so much for being with us.
Good to be here.